everyone. My name is Nady Peralta. I am an attorney with Legal Aid Justice Center as well, and with me is Gabby Lazo, who is our Arlington Housing intern. We work, as Ben said, Legal Aid Justice Center. The big difference between our organizations is that Legal Aid Justice Center represents undocumented immigrants. Legal Services Northern Virginia, I'm going to mix that up at least twice more. But Legal Services of Northern Virginia represents everyone else, and together we try to meet the needs of the low-income community in Virginia, and in particular for our office, the low-income immigrant community in Northern Virginia. We'll start just by giving the general disclaimer that what comes next, the presentation for today, is general information. So anyone who has questions specific to their case should reach out to us separately. And I know right now we're all here instead of at the tables, but I have my business card in the back. I know Ben does as well. So if you need to reach us and we run out of time today, or for whatever reason we can't touch base today, please take our information and we can talk separately later.
So this makes clear what we help with: evictions, various financial matters such as foreclosures, unemployment claims. I think may be a little anachronistic. I'm not sure how much we do with that now, but still some. Wills and powers of attorney. Again, all these services are free, so we can help you write up a will or a power of attorney. And medical directives. We help with nursing home discharges, particularly if people have been improperly discharged from a nursing home. Garnishments may be a bit confusing. If you're facing debt, credit card debt, or you've been a victim of fraud in a sale, such as an auto sale, we can help you with that. Not so much anymore. A variety of family issues such as custody, also guardianship. We do adult guardianship, but also guardianship for people who are becoming adults, turning 18. Tax questions and bankruptcy. We have very good people who work on those areas. And public benefits. We don't do criminal cases. We don't do criminal defense or traffic citations. Unfortunately, we do not work on immigration issues, and we don't do torts. We don't do personal injury.
And I'll just briefly share, I know this is a list, we don't have to go through everything. We're all here for housing and we represent tenants, but I wanna give you an idea that broadly at Legal Aid Justice Center, where I work, we do eviction and tenants' rights. We do consumer work. So if you have medical debt or if you have credit card debt, we're doing some auto cases. So if you have debt related to your vehicle, as well as education issues, criminal record expungement, specifically expungement. So we don't do criminal law, but if you need your record expunged, police misconduct, and public benefits. In general, if you call us and there's something that you need that we cannot provide, we can make a referral though. So it's not, I don't mean for everyone to memorize this list. So what we don't do in general, we don't do criminal or traffic cases. We don't do wills, family law, personal injury, tax, or employment issues. Again, we represent undocumented immigrants and both organizations work free of charge. So it's really important to just reach out to us. Even if you end up going to a private attorney, we can get you on the right road for free.
Okay, good afternoon, everyone. So my name is Gabby Lazo. Thank you all for being here today. I'm just going to walk through the Virginia Residential Landlord and Tenant Act, and we'll begin with your rights as a tenant. So the Virginia Residential Landlord and Tenant Act, also known as VRLATA, protects most tenants renting a place to live in Virginia. Tenants also have rights under fair housing laws, and for those living in subsidized housing, federal HUD regulations may apply. Alrighty, so as a tenant, you have the right to a safe and habitable home. You have a right to a written lease. You have the right to receive a proper notice of any changes to rules or access to your unit, unless it's an emergency. You have the right to organize or join a tenant organization. And importantly, your tenant rights, it doesn't matter of your immigration status. So whether you're documented or not, the law still protects you. And so what happens if your landlord does not offer a written lease? So the law automatically treats it as a 12-month lease with 12 equal payments. In addition, it's important to know that the landlord cannot charge can't exceed 10% of the rent that you owe, and the security deposit can't be more than 2 months of rent. Essentially, so if you don't have a written lease, the VRLTA Act, as I mentioned before, becomes the terms of your lease. So written notice or not, written lease or not, you're still protected under the law. Now, while you have rights as tenants, you also have responsibilities. This includes paying rent on time, not disturbing neighbors, keeping your home in good condition, and providing access to your landlord with reasonable notice. Now, some helpful things to remember, there are key few things that can really protect you as a tenant. First and foremost, reading your lease carefully before signing it. If you have any questions, please ask your landlord. You have the right to know what you're agreeing to. Second, keep everything in writing and keep copies for yourself. This includes maintenance requests, notices, agreements with your landlord, anything, because if a dispute ever comes up, this can be your defense strategy. It shows the judge or anyone else that is helping you that you tried to fix the issue right away first. Oh, I also did want to mention, sorry, you are responsible for the behavior of your guests and anyone else living in your home. It's also important to know that when you are leasing a unit with someone, you are both full responsible for the amount of rent payment. So for example, if Nady and I are renting a unit for $1,000 a month, the law doesn't automatically assume that we each pay $500. So the landlord could still come directly to me for $1,000, vice versa, if Nady doesn't pay her part of the rent. Now, regarding living conditions, your landlord is required to maintain the property in a safe and livable condition. This includes making repairs and informing you of any health risks like mold or pest treatment. Your landlords are also required to ensure that the critical systems in your home are working. This includes plumbing, water, ventilation, etc. Now, if something is broken or unsafe, you have the right to request demands. We recommend for you to putting in writing, as mentioned before, because this can really protect you as a tenant.
I just want to add a thought that if that's difficult or for whatever reason not possible for you to make a writing about maintenance request, we have forms in the back. So it's very easy to just fill them out and they're bilingual. So you can have a copy of whatever document you give to the landlord to let them know that there's an issue.
Now, what happens if your landlord isn't making the repairs after you notify them, especially if the issue affects your health or safety? Well, you have a few legal options depending if you want to stay or leave the property. One option is called tenant's assertion. This is when you file a case in court and ask a judge to step in because the landlord isn't maintaining the property the way they're supposed to. For this, you would have to give the landlord a written notice with very specific language telling them what needs to be fixed. If they don't fix it in a reasonable amount of time, usually 30 days, you can file a tenant's assertion. Again, this is a very complicated process, so we encourage you to talk to a lawyer if you are considering this. Now, some other helpful things to remember. If something in your home needs repairs, start by writing your landlord a letter. You can also contact code enforcement or a housing inspector to report the issue. But remember, if your home has problems or housing code violations, you cannot withhold rent. Rent still needs to be paid. But instead of giving it directly to the landlord, you may be able to pay it into something called an escrow account managed by the court. Once you establish that the money is in escrow, you'll explain your situation to the judge. If the judge agrees that the landlord failed to maintain the property, they may order the landlord to make repairs or even lower your rent. But if the judge sides with the landlord, that escrow money might go to them instead. Because again, this process is a bit complicated, we encourage you to talk to an attorney before filing anything. Another option is called a 2130 notice, and this is for when you want to leave the property because of the bad conditions. For instance, you would send a letter telling the landlord they have 21 days to fix the issue, and if they don't, you're ending the lease in 30 days. But again, this letter has to follow specific rules and language, so consult a lawyer. There's also another option called repair and deduct, where you hire a licensed professional to fix the problem and you subtract that cost from your rent. This option also has specific conditions, so again, talk to a lawyer if you're considering this. These are different avenues you can take, and there are others. If you think you might be subject to one of these, or you're unsure what applies, please talk to an attorney moving forward. There are certain things landlords are not allowed to do. They can't make you sign away your rights or share your private information without your permission. They can't charge excessive fees, and they can't retaliate against you, such as like raising rent or decreasing services. They also can't include illegal terms in your lease, like forcing you to pay their attorney fees or accept unsafe conditions. Even if you signed it, those parts are illegal. They can't be enforced. And if your landlord tries to use them against you, you might be able to get your money back or even have them pay your attorney fees. So if something in your lease doesn't seem right, it's always a good idea to check with a lawyer. Now, with late fees, your late fees cannot be more than 10% of the rent that you owe. So if your portion of rent is $100 per month, the late fee can't be more than $10 per month. Now, regarding security deposits, I know that for a lot of people, this is a significant amount of money. In many cases, it's money you're counting on getting back when you move out, or maybe to help cover your next place. It's important to know that for security deposits, landlords can't charge more than 2 months' rent for a security deposit. That's the legal limit. When you move out, your landlord has 45 days to return whatever's left of that deposit. But they can take money out to cover unpaid rent or actual damage to the property. You have the right to be present during the move-out inspection, so I encourage you to go and see for yourself what they're documenting. And if you forget to give a forwarding address, they're required to hold that deposit for a year before sending it to the state.
So before we move on to evictions and how that works, I want to just take a moment to talk about special cases with immigrant households. Obviously, right now we're living in a time where there's like another layer of concern around housing for folks who are in mixed status households or in immigrant households. So we just wanted to take like 2 minutes to give you some information about that. So in general, I would say the laws are changing quickly, and it's very difficult today to say what is true and what is available for you as a defense or as a protection in 1 month or in 1 year or in 3 years. It's really hard for me to tell you right now that what exists as a system is going to be the same going forward. So as always, I know you've heard Gabby say it, I'll say it again. Check with an attorney if you have any concern, and make sure that you talk about this specifically, because these things are changing and you want to know what's true in your case. So if ICE knocks on your door, the most important thing you can do for yourself is to check if they have a warrant. If they do not have a warrant, they may not enter. If they do have a warrant, ask for them to slide it under the door, through a window, and just make sure that you're saying, I do not give you permission to enter the home. I just want to look at your warrant. And what you want to look for on that document is a name and an address and a judge's signature. If the name is incorrect, if it's not somebody who lives at the address, or if the address is incorrect, if they knocked on the wrong door, then the warrant is not valid. They cannot pass. You have to just let them know and send them on their way. The judge's signature is also required. And that's at the bottom of the page. It gives them the authority to enter. If there is no signature on the warrant, it's just a piece of paper. So you are well within your rights to give it back to them and say, this is not a valid warrant, and not let them in. If you are in a mixed status household, so there's 2 things I want to say here. One is more from an immigration perspective, and one is more from a housing perspective. For an immigration perspective, I think it's really important to consider that the sad truth is that there's a situation around collateral arrests when there's a mixed status household. There's people in the home who maybe are not subject to the warrant, but they're there, and that's a risk. So one thing folks can consider is that if you are the individual named on the warrant and you step out of the building, close the door behind you, there is no reason to go into the house at all. They've got what is on the warrant. On the other hand, if you are listed on the warrant and you let them in, which is to say you open the door and tell ICE they can come in, now they've been given permission to enter the property and to go beyond the bounds of that warrant. So that's a decision every family has to make, and it's a decision that no family should have to make. But I wanted to put that out there and just say it because it's important to know that that's an option. And then from a housing perspective, as I said before, mixed status houses get some benefits that are going to be affected if the rules change. I know we talked a little bit about mixed status household benefits that are from Arlington specifically, and I know there are some federally as well. I cannot tell you today exactly how things might change, but what I can tell you is that there will be notice. So you should not be finding out, for example, the day before you lose a benefit that you will be losing it. You should be expecting that you'll get a letter in the mail or an email or any other kind of communication first that something has changed with your benefits. And if and when you get that letter, you should reach out to an attorney right away so that you can get a clear understanding on how your particular situation is going to change. Okay, last thing, let's see. If you feel you're at risk of detention, one thing that you can try to do is leave things prepared in case that does happen. And when I say that, I'm talking about, for example, executing a power of attorney document and having a family plan. When I say a power of attorney document, this is a legal document that allows somebody else to take control of your assets in general. So for example, if I feel like there's a risk that I'm not going to be able to manage my bank account, I can make a power of attorney that says, in the event I cannot access my funds, or in the event that I am detained or arrested, Gabby Lazo has power of attorney to access my bank account and spend the money however she feels appropriate. So that's obviously a very powerful thing. You need to speak with someone that you trust deeply and that understands your vision for your assets, so that they're not abusing that authority that you give them. It's a big authority, but that is one way to prepare. And when I say a power of attorney, I use the example of a bank account. It doesn't have to be that. It can be the property that you live at. It can be your cars. It can be temporary custody of your children. And that I have to say with like an asterisk. I do mean temporary. It's not a custody agreement that you can come to, but you can give somebody else temporary authority to make decisions for the care of your children, or for example, to pick them up from school, and that would be through a power of attorney document. Another thing I mentioned was a family plan, and that means making sure that everyone in your household knows what to do in case you are detained. So that's maybe gathering your most important documents. If you have your birth certificate, your passport, if you've ever been involved with immigration court or immigration authorities, any documents related to that, having them all in one place and knowing where that is and sharing where that is with people who are going to know about your plan. And I say that really carefully because it's not information that you want to give to everybody. I wouldn't want to say, I keep my passport on the top shelf of my bedroom closet, which is not where I keep it. But that's not something I would want everybody to know. But if there's someone that you are planning with, so if you have your partner or a family member or a friend that you trust deeply, they should know where those things are. And together with your family documents, you're going to want to keep the phone number of an immigration attorney if you have one already, or if you want to be in touch with one, then you would, for example, if you want to take my card and call my office in case of an issue, you want to put my business card in there with your documents. And I'll just, because I use that example, I should say, I'm not an immigration attorney, but we do have immigration attorneys in our office. So if that's something that you wanted to talk about, it's beyond the scope of what we're doing today, but you can definitely feel free to take a card from the back and we can be in touch. So in general, I know that we're a little bit outside of housing, but I wanted everyone to know the considerations are a little different in mixed status and immigrant households, but we're here to help in any way that we can. And if you have questions, we'll be in the back. All right, I'll pass it back to Ben for more on evictions.
I'm going to say something critical before I get to this slide. Eviction is a legal process. It consists of a number of steps, and it takes time because it goes through the courts. So the main thing to keep in mind is if you get an eviction notice on your door from your landlord, and if your landlord wants to evict you, the landlord must give you a notice. That's just the first step. That is not itself an eviction, and you don't need to leave. Your landlord is simply notifying you that she is beginning a process of eviction. In fact, sometimes landlords post a notice and then do nothing more. But if the landlord wants to evict you, the landlord, after posting the notice, has to go to the courts and set up a date for an initial hearing, and also make sure that you get a summons from the court telling you that you have a date for that hearing. So keep in mind, you aren't evicted when you get the notice. Most evictions, by far, are just about payment of rent. That rent is owed, and it's overdue. And in that case, you will get a notice that says on the 5th day after the rent is due, that says you have another 5 days to pay, or the landlord's going to go to the court. There are also what are called 2130s. You've heard about that before. What it means is, and it's a little confusing, sometimes a landlord will say, look, you're violating the rules of our lease. There's a rule that says no alligators on the balcony. You have a whole family of them on the balcony. I told you not to. You have 21 days to get your alligators off the balcony, or you have to be out in 30 days. So that's a behavioral eviction. That is, the notice says you have 21 days to fix something, or you have to be out in 30. And I'll tell you, many 2130s are badly written. They don't give the tenant a very clear idea of what has to be fixed, and they don't give the tenant a very clear idea of how the tenant then can show the landlord they've been fixed. So rule of thumb, always get in touch with a lawyer when you get a notice of eviction, regardless of what kind it is. End of lease. Depending on the lease, you immediately go from a 12-month lease, a year lease, to month to month. And if the landlord wants to evict you, the landlord has to give you sufficient notice, at least 30 days. The same for raising the rent. It's often more. Again, the landlord must give you a notice. Here it says, unless the reason is a crime and you're endangering others on the property. Clearly, if the police show up and escort you off the property, that's a pretty effective eviction. But short of that, even an immediate eviction, a notice that says you were immediately evicted, still has to go through the courts. Immediate is a bit of a misleading term. It's still a legal process. Keep in mind, drugs are taken very, very seriously under the law. So that's why it's emphasized here. Presence of illegal drugs can really get you an immediate eviction. Again, most evictions are about non-payment. This is a little out of order, but if you get evicted because you haven't paid, you can fix that and make the eviction go away. Essentially, that is, it must be dismissed if you pay up everything that you owe in time. Again, that's not up to the discretion of the landlord. The landlord says you haven't paid. You go to the landlord and say, what do I owe? You pay it. You get some kind of affirmation that you have paid. You need to make sure that the landlord admits that you have paid up, and then the eviction has to stop. This is a little technical, but sometimes a landlord who's tried to evict you may actually make a mistake. It says here, waived his or her right to evict you. Leases should have a clause that say, or some leases have a clause that say, okay, the landlord can evict you for non-payment of rent, but the landlord can keep accepting money from you if you happen to pay the landlord. That doesn't nullify the landlord's eviction. If that language isn't there, the landlord has waived the eviction by accepting any further money from you. If you receive court paperwork, I mentioned that the landlord, after giving you a notice, has to go to the court, and the court has to issue a summons with a date for you to show up. Do not ignore any paperwork from the court. This may be more important than a doctor's appointment. Let's say it is. If you have to be at court on time, or you lose. You lose your case. There are often cases that are dismissed, or another term is non-suited. For example, I told you if you pay up in time, the landlord has to dismiss your eviction case. Once a case has been dismissed, at least since last July, it's removed from the court records. So anyone who looks at the court records, and court records are public, if a case has been dismissed in the case of an eviction case, then that case is removed from the court records and there's no evidence in the court records that it ever occurred. Any case that was dismissed or non-suited before last July, you have to file a piece of paper for each case that was dismissed in order to get it removed from the court records. A little burdensome, but you have a right to go to the clerk's office or look up online, see if you have any cases you may have forgotten about that have been dismissed, and then file the papers, and they have to remove them from the court system. Sorry, this says 2025. It's actually since last July. 24. Unlawful exclusion. Okay, it's a legal process, right? Eviction? Your landlord can post a notice. Your landlord cannot lock you out of your house or try to compel you to leave by shutting off your water or your electricity or posting a guard dog in front of the door. That's what's called self-help, meaning the landlord has helped himself, and it's illegal. The landlord can only evict by going through court. No changing of lock, no improper utility shut off. The landlord can't say, hey, you're late on rent, no more utilities, no more water. As I say, the landlord has to announce to you that you are being evicted and then go through the legal process. Again, this is a bit technical. If your landlord does try to evict you on his own, this gives you steps of what you can do. I'm not going to go over them here. Get in touch with a lawyer. If your landlord has done something to make your place so uninhabitable you cannot go into the apartment, get in touch with a lawyer. I'm going to make one point, though, and I want to repeat. It's really repeating what Nady said. Just as the landlord can't help himself, you can't exactly help yourself. If you owe rent, keep paying your rent. Your apartment could be overrun with rats. Talk to those guys over there. Or something's not working. You have to keep paying your rent. That's Virginia law. It may not be fair. It's Virginia law. But you pay your rent to the court. You have to be prompt. You have to pay the full rent. You have to do it month by month. But now you pay it to the court. You go to the court and ask them how to set up an escrow account. If you stop paying your rent, even though you're overrun with rats, you're responsible for the rent, not the rats. So the landlord is going to say, where's my rent? Now I'm going to evict you because you're not paying. I don't care about the rats. You haven't paid, you're out. So protect yourself. Always pay your rent. You've seen already from Hallie about fair housing. This is more about denial, but you also cannot be evicted for requesting a reasonable accommodation or a reasonable modification, and you can't be retaliated against in any way for making such a request. One more basic point. I keep emphasizing how eviction is a legal process. Another basic point, lawyers say this in their sleep, drive their spouses crazy. Write it down. Anything that happens between you and the leasing office, write it down. They also have to write it down. If someone comes up to you, someone from the leasing office, and says, hey, you have to leave in 5 days, that means nothing except that there's someone antagonistic to you in the leasing office. It has no legal meaning. They can't go to the judge and say, hey, I told him he has to leave. It's oral. It means nothing. So they have the burden of being in touch with you always about your rent in your apartment in writing. And it's the same with you. To protect yourself, put everything in writing. You can do it as an email inquiry or even a text. But the whole point is, if you ever have to go to court, we need proof. And testimony about what I said or someone else said doesn't count for very much. Write things down and demand that they be written down when the leasing office is in touch with you. So, get in touch with us. That's maybe the third most important point. Feel free to reach out. It costs you nothing. If we can't take the case, we will at least give you advice or direct you towards someone who can. One other point about immigration. Although things are worse for immigrants now, your rights as a tenant have nothing to do with your immigration status. So if you're undocumented and your landlord is abusing you, you can file a complaint about it. Your landlord cannot use your immigration status in any way to retaliate against you or as a grounds for an eviction. It has nothing to do with your rights as a tenant.